G'day everyone, this is Terry from Koala-Krafts, and this is a whip, and I'm chatting, I suppose, giving you some information on what's going on with a few high-profile court issues. The first one being Alec Baldwin. Apparently all the charges against him have been dropped, and apparently this is because of the way the prosecutors acted, and how they were trying to file the charges with an update so he would get more time in jail. Apparently what they were going to charge him with wasn't, wasn't a charge at the time of the incident, so they couldn't, or they shouldn't have charged him with the upgrade. The armourer is still being charged, and that's still going to go to court, but Alec Baldwin's was dropped without prejudice, which means that further down the track he can be recharged, but reading what's going on around the interwebs, it would be more than likely that this won't happen because of the way that the prosecution acted in this matter. So I would say they got a little smack on the bottom and told never to do that sort of thing again. Anyway, anything I say in this video is my opinion only, and I have done some research to find out these details, but it's my opinion only. So, yeah. Also, if I could ask you to subscribe to my channel and click the bell so that you'll get notified when I do another video, and press the like button too if you're so inclined. This next tidbit is in relation to the Trump matter, but it's Alvin Bragg as the plaintiff, or Alvin Bragg Jr. as the plaintiff, and the defendant is Jim Jordan, who is a committee on the Judiciary of the United States House of Representatives, and also Mark Pomerantz. Mary Kay Viscol was the judge, and she states the request by Manhattan District Attorney Alvin Bragg Jr. And going forward I'll just call him Bragg, for a temporary restraining order enjoining enforcement of the subpoena issued to Mark Pomerantz, further just referred to as Pomerantz, by the Committee of the Judiciary of the United States House of Representatives, chaired by Congressman Jim Jordan, is denied. The subpoena was issued with a valid legislative purpose in connection with the broad and indispensable congressional power to conduct investigations. It is not the role of the federal judiciary to dictate what legislation Congress may consider or how it should conduct its deliberations in that connection. Pomerantz must appear for the congressional deposition. No one is above the law. So that's what it's mainly about. Pomerantz didn't want to appear for a congressional deposition, but now they're saying that he should because no one is above the law, which is true. On April 6, 2003, the Committee of the Judiciary of the United States House of Representatives issued a subpoena directing Pomerantz, a former pro bono employee of the Office of the District Attorney for New South Wales, for New York County. Going forward, I'll call this Danny, D-A-N-Y, to appear on the 20th of April 2023 to testify at the deposition touching matters of inquiry committed to the declaration of Theodore J. Boostris, I don't know how to say that, Jr. The subpoena does not request that Pomerantz produce any documents. So he just has to go and appear, but doesn't have to produce anything, I suppose, to prove or not prove anything that he's saying. This subpoena was accompanied by a letter from the chairman of the committee, Jordan. The letter requested that Pomerantz's appearance, due to his unique role as a special assistant district attorney leading the investigation into President Trump's finances. It further explains that Pomerantz has already discussed many of the topics relative to the committee's oversight in a book wrote and published in February 2023, as well as several public interviews to promote his book. Jordan notes that Danny has acknowledged that he'd used federal forfeiture funds, I just can't understand that, in its investigation of President Trump. And the committee was considering potential legislative reforms, such as broadening the existing statutory right of removal of certain criminal cases from the state court to the federal court. The book referenced in Jordan's letter is People versus Donald Trump, an inside account written by Pomerantz and published in early 2023. As its subtitle indicates, the book recounts Pomerantz's insider insights, mental impressions, and his front row seat to the investigation and deliberative process leading up to the Danny case against former president and current presidential candidate Donald Trump. Among Pomerantz's observations were: within Danny, the case against Trump arising out of a payment to so-called hush money to Stephanie Clifford, what was referred to as the zombie case. The facts surrounding the payment did not amount to much in legal terms. Paying hush money is not a crime under New York state law, even if the payment was made to help an electoral candidate. Creating false business records is only a misdemeanor under the New York law. There appeared to be no felony state crimes in play. To charge Trump with something other than a misdemeanor, Danny would have to argue that the intent to commit or conceal a federal court crime had converted the falsification of records into a felony. No appellate court in New York has ever upheld or rejected this interpretation of the law. The statutory language under which Trump was charged is ambiguous. There was a big risk that felony charges would be dismissed before a jury could even consider them. The Trump investigation should have been handled by the US Department of Justice rather than by the Manhattan District Attorney's Office, which is probably true too. Federal prosecutors would not have to torture or massage statutory language to charge Trump with a violation, as Danny would have to do. Again, Danny that I'm talking about is the Office of the District Attorney of New York. Federal prosecutors previously looked into the Clifford hush money payment and did not move forward with the prosecution. There is a statute of limitations issue, and this is a big issue with these charges, how they're going to get around the statute of limitations. Anyway, there is a statute of limitations issue with the Danny case against Trump. Numerous Danny prosecutors were skeptical about the prosecution of Trump and were referred to internally at Danny as conscientious objectors. Woohoo! The invoices and requests for payment from Michael Cohen in connection with the Clifford payments in a supported effort of camouflage reimbursements were made throughout 2017. The Danny prosecution, and don't forget, these are things that were written in Pomerant's book that the judge is talking about. So it's not just what the judge has said. This comes out of the book, from what I understand. The Danny prosecution team discussed Michael Cohen's credibility as being one of the difficulties in the case. Well, as you probably know or may not know, Michael Cohen was charged and jailed for misleading court, or lying to the court and lying to others in relation to other matters. At one point, Bragg commented that he could not see a world in which Donald Trump would be indicted and would be able to call Michael Cohen as a prosecution witness. That paragraph there didn't make sense. That's why I was having trouble getting around it. While Pomerantz acknowledged Bragg's right to make prosecutional decisions, Pomerantz viewed himself as a more experienced and qualified than Bragg. Pomerantz makes the point that he was finishing law school when Alvin was a toddler. Pomerantz resigned from his pro bono position at Danny when it became clear to him that President Trump would not be indicted. Pomerantz told the DA that he was responsible for a grave failure of justice because he would not authorize Trump's indictment. Ultimately, in March 2023, Bragg did, of course, indict President Trump and bring the zombie theory back from the dead once again. Jordan and the committee first tried to acquire information from Pomerantz and Danny voluntarily. While the Danny General Counsel offered to meet and confer with the committee to understand whether any legitimate legislative purpose in the requested materials, Danny declined to provide information and instructed Pomerantz not to comply with the committee's request. On April 11, 2023, Manhattan District Attorney Bragg, who is a plaintiff, one of the 5 local district attorneys for the 5 boroughs in the city of New York, filed a 50-page complaint in this court naming Jordan, the committee, and Pomerantz as defendants. Bragg simultaneously filed a motion brought on by an ex parte proposed order to show cause, seeking a temporary restraining order and a preliminary injunction in joining Jordan and the committee from enforcing the subpoena served on Pomerantz, and enjoining Pomerantz from complying with the subpoena. The first 35 pages of the complaint have little to do with the subpoena at issue and are nothing short of public relations tirade against former President and current presidential candidate Donald Trump. The same is true of the vast majority of exhibits accompanying the declaration. Of note, the complaint acknowledges that Danny used federal forfeiture funds in investigating President Trump or the Trump Organization. Moreover, Bragg concedes that Danny was aware that Pomerantz was writing a book about the Trump investigation, and asked to review the manuscript pre-publication. Pomerantz declined. At heart of the complaint simply includes 2 requests for declaratory and injunctive relief directed at the congressional inquiry. The reality is that, as framed, this action is merely a motion to quash a subpoena dressed up as a lawsuit. And it just goes on about different things, going backwards and forwards. And we will just go to Bragg is not entitled to a temporary restraining order. In the Second Circuit, the same legal standard governs the issuance of preliminary injunctions and temporary restraining orders. It just goes on with cases and all that sort of thing. So we'll just go down to the conclusion if there's one here. So they're just going backwards and forwards with the backwards and forwards subpoenas. Conclusion. The motion for a temporary restraining order enjoining the subpoena to depose Mr. Pomerantz and enjoining Mr. Pomerantz from appearing is denied. In our federal system, elected state or federal actors sometimes engage in political dogfights. Bragg complains of political interference in the local Danny case, but Bragg does not operate outside of the political arena. Bragg is presumably acting in good faith. That said, he's an elected prosecutor in New York County with constituents, some of whom wish to see Bragg wield the force of law against the former president and current candidate for the Republican presidential nomination. Jordan, in turn, has initiated a political response to that he and some of his constituents view as a manifest abuse of power and nakedly political prosecution funded in part with federal money that has the potential and interference with the exercise of presidential duties and with an upcoming federal election. The court does not endorse either side's agenda. The sole question for the court at this time is whether Bragg has a legal basis to quash a congressional subpoena that as issued with valid legislative purpose. He does not. So guess who won? The parties are encouraged to speak with one another to reach a mutually agreeable compromise regarding how the deposition of Mr. Pomerantz will proceed. This court will retain jurisdiction over the dispute and any ancillary claims arising out of the inquiry by the committee relating to the use of federal funds in a manner that may influence the 2024 presidential election. In other words, Bragg may not file successive proceedings under a different index number if and when the committee in fact issues another subpoena that he finds objectionable, or if there are issues with respect to Pomerantz's deposition. The parties are hereby ordered to file a joint status report within 30 days of the date of this order. And it says, so ordered on the 19th of April in New York, and signed by the United States District Judge Mary Kay, and I can't pronounce her last name, Vyskocil. And that is that. But from what I understand, I can't find the paperwork at the moment, but what I understand is an appeal has been lodged against this order. So we'll try and see what happens down the track. But with this piece of documentation, they have to go to the committee and be deposed. But as I said, there is an appeal also. So that is what is the next step, I would assume, on this matter. So who knows what's going to happen. I mean, they just go backwards and forwards and issuing subpoenas, and I suppose what comes out of the committee will have a bearing on the case that Trump has been charged, and we'll see what happens. But anyway, that's about all. I will stop here, and I hope everybody keeps safe and look after yourselves and your family, and make sure you tell them you love them, and I will talk to you again really soon. Have a good day or night or whatever it is where you are, and I will talk to you again soon. Don't forget to subscribe. I'll leave the whip going, and as I said, see you soon. Bye bye for now.
One or the other. One or the other. What movie are you going to go and see? Oh, okay. You gotta be too easy. Mm. Oh, pine milk. Pennsylvania shouldn't have cow's milk. Mm. Water probably would have been better. Just to stop it dehydrating anymore. Mm. Mm. Wouldn't surprise me. I'd be embarrassed to have people at his place. Yeah, the cat's wing and, no. Yeah, what do? You clean it up. He just leaves it there. I don't know how you can walk into it, to be honest. I don't know how that girl and the mother lived there. Mm. He's getting comfy. Or he's getting comfy, one of the two. Yeah. Gotta be careful with those pronouns, girl. Yeah, no matter. As I've said a million times before, we don't even use pronouns here. Mm. They're gonna call you the dog lady. Instead of the cat lady. Mm? No. Oh, yeah. Yeah, when you, yeah, after me, you make. Took a bit because it's nearly the same colour as your shirt. Going for a walk exploring. What the hell are you? I don't know what you are. I don't know what you are. You don't look like a cat. Still. You're probably better off going to bed. What time is it? Feed the pup so it's got a full belly and go to bed. Ah, the kitten, sorry. Yeah. I'm so used to saying puppies to you. Good. Hi, Dad. Okay. Just... Sweet, it's gorgeous. No, but it didn't blow up. It didn't blow up, it dismantled. Yeah, see, I had to laugh when I heard that. Okay, because it was just